All right, well, we'll get going this morning. Thank you, everyone, for being here this morning for this installment of the Pro Bono Partnership of Atlanta's monthly webcast series. Today, I'm excited to have PBPA's own Executive Director, Rachel Spears, joining us to talk about an incredibly important topic, questions board members can ask to keep their nonprofit out of legal trouble. This is part one of a two-part series. Rachel is not only our executive director, but she's also an attorney. She's been advising PBPA clients from day one of our organization, 16 years ago, I think.
17.
17, wow, 17 years ago. So she has some great insight to share with y'all today. But before Rachel gets into the substance of today's presentation, I'd like to tell you, our audience, a little bit about PBPA and our mission. PBPA provides free business legal services to Atlanta area nonprofits. We do this by connecting them with volunteer attorneys from Atlanta's leading law firms and corporations. PBPA provides direct legal services to our clients, and we also provide free services to any interested individual or nonprofit through our website. Who are our clients? They are small 501c3s based in the Atlanta area, and they themselves have clients who are participants who are low income or disadvantaged individuals. And the organization is otherwise unable to afford legal services. If you are interested in applying to be a client, you can visit our website and fill out the request for legal assistance. Also on our website, we have a wealth of resources, including articles, webcasts, and podcasts. We do anticipate that we might be returning to in-person workshops too in the near future. So stay tuned for that. And just a quick disclaimer, because we are lawyers and we like disclaimers, please keep in mind that today's presentation and any questions that Rachel answers during the course of today's presentation is just general information. If you have specific questions about your nonprofit's needs, please reach out to an attorney. Today's presentation is copywritten, and we will be providing a copy of this recording and the slides on our website in a few days. And we'll also provide these slides to you either in the chat or the Q&A box during this presentation today. So that's all for me right now. I'm going to turn over the mic to Rachel.
Thank you, Sarisha. Before I get started, I'm going to make one more request since the chat doesn't appear to be working. If you can look, add to the Q&A a little bit about yourself. I'm really interested to know your role at a nonprofit. That'll help me in presenting the presentation, but also feel free to share your name, what organization you're with. I would love to see that. So Sarisha already shared about me. And as far as the topic today, we are going to cover the top 10 questions you should ask to keep your nonprofit out of legal trouble. When we marketed this, it was more to board members, but really it's anybody that's involved in the operations of a nonprofit that can benefit from this information. We're going to cover probably about 5 of the top 10 today, and then we will come back in September, I think September 22nd, we have it at the end to present the second half. It's a lot of information. And while I call it a top 10 list, because I'm old enough to have watched David Letterman and I always liked those lists, if you counted, it's probably a lot more than 10. So I'm sorry I snuck in some extras there. The purpose of this is to identify issues you may not be aware of. We want to identify them before they become a problem for you so you can address them. I'm just going to kind of bring them to your attention today. I can't possibly cover everything. And So I hope you would take advantage of the resources on our website that Sarisha mentioned. If you're a client of Pro Bono Partnership, I'll hope you reach out to us and get our help or get help from a trusted advisor to walk you through some of these issues that we identified today. Finally, we don't have time to go over every legal issue that could come up. These are just the ones that over my 17 years doing this seem to come up over and over again with our nonprofits. Know that this isn't everything, but these are the biggies in my mind. And the goal is to keep your nonprofit out of trouble, help you focus on the mission of your organization so you can keep doing your important work. We are going to cover employment, your tax exempt status with IRS regulations, insurance and risk management. We may get through those today, and then we'll come back and talk about corporate governance, state taxes, and fundraising. Randy, you can advance. So I'd like to start just by setting the stage of why this matters. You're here today, so that's the first step, but why does this matter to your organization? And I want to give you this context to help you understand how important it is to not just learn this today, but follow up on these things that you feel like maybe y'all are not in compliance with. So what we see our clients face who are not in compliance with these things are audits by the IRS, the Department of Labor, fines and penalties, lawsuits, which can be extremely costly, as you know, theft or embezzlement of your organization's funds, which can lead to really the worst thing of all, which is damage to your reputation as a nonprofit. That can result in loss of grants for donors. Worst case scenario, you've got criminal penalties. And then of course, really the death of your organization would be the loss of your tax exempt status. So not all of these things can result in such dire consequences, but even if they result in some lost donations or some wasted resources for your nonprofit, that can be really serious. Go ahead, Randy. So I always start with this question because I really see it as the issue that nonprofits get tripped up on a lot, not just nonprofits. Any employer gets tripped up a lot, any business, and it can result in surprisingly horrible consequences. I want to start with a quick story, which is a client that came to us. It was a health clinic for the uninsured doing really important work. By the time they came to us, they were already having financial trouble. Unfortunately, they were really insolvent. We ended up having to just help them shut down in an orderly manner. But in working with the organization, I realized that a lot of their financial problems went back to one independent contractor. It was somebody that they were treating as a contractor who really should have been treated as an employee. And we'll talk about how you determine that. Somehow the IRS got wind of it. The IRS wanted their taxes. This person had not paid any taxes. So they went after the nonprofit for the unpaid payroll taxes, as well as fines and penalties. And it was just too much for them. They entered into a payment plan with the IRS, couldn't keep up with it, ultimately shut down. So something as simple as one misclassified person can really have bad consequences for the organization. Next slide. So this question of contractors or employees, sometimes I'll hear nonprofits call them consultants, whatever you call them, it is somebody that you are giving a 1099 rather than a W-2, and you're not taking out payroll taxes with every payroll. IRS, if they had their way, everybody would be an employee. They would get those taxes right off the bat, right? There is a way in certain instances where somebody can be a contractor, but you need to make sure that they meet the criteria both the IRS and the Department of Labor set out. The IRS, the US Department of Labor, the Georgia Department of Labor, they all care about this issue. And while there are a lot of factors and their tests are a little bit different, the most important question to ask is who has control in this relationship between your organization and this worker to determine whether they can be treated as a contractor. Who sets when they work, how they do their work. To the extent that it's really the organization making those calls, they're going to be an employee. And to the extent it's really the contractor that has control of how they do the work and when they do the work, they're more likely to be able to be a contractor. The IRS, I think, has a 20-factor test. No one factor kind of makes the decision one way or the other, but the kinds of things they look at are who is setting the schedule, who supplies the equipment they need to get the job done. Can the person engage other people to help them in their work, kind of subcontract it out? How integral to the work of the organization is the work that this person is doing? So to give a quick example, if you hire somebody in your organization to come in, not that many people come in anymore, but come in Monday through Friday, 9 to 5, answer the phones, you give them a computer, you tell them what to do, you give them a handbook, they're on the website, they get a business card. That's clearly an employee. On the other end of the spectrum, if you have your organization owns a building and you need somebody to come in and keep up the grounds, mow the lawn, and they, do it once a month when they want to do it and, normal hours, and they hire people to help them do it, clearly a contractor. The tricky thing is there are a lot of people in between on that spectrum as far as control. That's where you really want to get some advice, whether it's from an attorney or even an HR professional, on how you're doing that, how to structure it. It is not enough to say, oh, this person wants to be a contractor. It's not enough to have a written contract with the person. You got to look at these tests and really meet that criteria before you make that determination of whether you are allowed to treat them as a contractor. Here's a great resource on our website. I encourage you, if your organization uses contractors at all, to really educate yourself about this issue and get help. Next slide. So why does this matter? The contractor versus employee issue really comes down to payroll taxes, number one, and also unemployment, which we'll talk about. IRS wants their payroll taxes. You have to withhold certain payroll taxes from your employees. One thing you don't have to as a 501c3 is the federal unemployment tax, or FUTA. FYI, you do not have to pay that, but you are responsible for everything else. This is where I think board members need to pay particular attention, but also employees of the organization. If your organization messes this up and is not paying payroll taxes, and the IRS comes after your organization for those taxes, they can come after employees and board members personally. So while you think as a board member, wait, I'm not liable, I'm a board member, don't we have protection from liability? Well, there's a big exception here, and it's the IRS, and they can come after you. And we've seen this happen where they've certainly come after employees and even board members to try to get those taxes. So keep that in mind. Next slide. So I mentioned that there's one other thing where this is relevant, the distinction between contractors and employees, and that's unemployment. So employees are eligible for unemployment, contractors are not. And sometimes the way nonprofits get caught, so to speak, by treating somebody as a contractor who should have been an employee, is if that contractor then goes and files for unemployment. Then the Georgia Department of Labor is going to come to your organization and make their own determination of whether that person should have been an employee, whether you should have been paying unemployment into the unemployment system, and whether you owe them unemployment at this point. So that's another way we see this come up. Just want to tell you a little bit about unemployment because this can be kind of tricky. So for nonprofits in Georgia, and everything I'm talking today is 501c3 nonprofits in Georgia. Nonprofits are not even covered by the Georgia unemployment system until they have 4 employees. And that 4 employees is a little bit more specific than that. It's like working 20 weeks in a calendar year. Don't quote me on that, but at some point, this kicks in where you have 4 employees and you are covered by unemployment. What's tricky for nonprofits is often you start with no employees or 1 employee, and it may take you a few years to get up to that 4 employees. And at that point, this kicks in and you've got to register with the Georgia Department of Labor, and you have long forgotten about this. So I don't know how, but somehow you're going to have in your mind for employees is some sort of trigger I need to check on. Because at that point, you are required to register your nonprofit with the Georgia Department of Labor and pick between two methods for them to get unemployment taxes from you. So the first method is what for-profits do. It's SUTA. They take state unemployment tax out of every payroll, and they use that to pay, employees that file for unemployment, former employees. Nonprofits have another option, which is the reimbursable method. In that case, they're not taking out payroll from taking out tax from every payroll. Instead, if you have a former employee who files for unemployment, they pay the unemployment, they're going to come back to the nonprofit to reimburse them for that. So as you make that determination about whether you want to choose the SUTA method or the reimbursable method, think about how often you have people file for unemployment with your organization, how many employees you have, do you have a reserve to cover that if you have to get an unexpected request or, not request, determination that you have to reimburse. Also, if you choose reimbursable, Department of Labor often requires you to put up a surety bond. So you're probably going to have to put up some money to begin with. So that's, a business decision about what you do, but I just want to mention that. And importantly, it kicks in at 4. All right, next slide. Let me just pause there. Sarisha, do you want to let me know if we have any questions kind of as I get to the end of each question?
I don't see any questions in the Q&A box yet.
Okay.
I just want to remind our viewers that if you have any questions, feel free to use the Q&A box for that. Apologies about the chat box. We're not going to be able to get that going again, but we'll use the Q&A box so you can type your questions up there for Rachel.
Thank you, Sarisha. All right, one more employment question I want to cover. Do we pay minimum wage and overtime as required by law? Next slide. So you'll see I pepper in here a few news items that show nonprofits having problems. This is an old one, but a good one because it shows that even the Ronald McDonald House can get sued for unpaid overtime. This was an employee who sued alleging that they worked overtime. Ronald McDonald House did not pay them time and a half over 40 hours like they were supposed to, so they ended up with a big lawsuit. This is something that any organization that has sort of a 24-hour operation needs to be particularly mindful of because it can be tricky if you have people sleeping there. How do you calculate what their 40 hours are? Even if you have employees that go maybe to out-of-town conferences, you might need to get some advice on how do we have them add up their time to make sure we're not going over 40 hours in a work week, or if we do, to make sure we're paying that overtime. Next slide. So when we talk about minimum wage and overtime, the law that applies here is the Fair Labor Standards Act. The Fair Labor Standards Act only applies to organizations with a certain amount of revenue, and there's some criteria to it, but I just want to alert you to the fact that the Fair Labor Standards Act also covers individual employees. So even if your nonprofit doesn't meet those criteria to be covered as an organization under the Fair Labor Standards Act, chances are all of your employees are covered. So go ahead and comply with the Fair Labor Standards Act because most likely it's covering all of your employees. So under the Fair Labor Standard Act, or FLSA, when it comes to the question of overtime, all employees are divided up between exempt employees and non-exempt employees. And the exempt is whether they are exempt from the overtime requirement. The overtime requirement says that employees must be paid overtime, which is time and a half, for every hour they work over 40 hours in 1 week. Notice that's in 1 week. So if you have somebody work 45 hours in 1 week, you can't make it up the next week. It's got to be within that week. You've got to give them, if they work extra hours on Monday because y'all have a big event. You know, if y'all are in a traditional work week, by Friday, try to get them to cut their hours so it doesn't go above 40. Otherwise, you are going to overtime. So I mentioned exempt or non-exempt. In order to be exempt from overtime, meaning your organization does not have to pay these exempt employees if they go over 40, they have to meet certain categories, and that the U.S. Department of Labor lays out. I'm not going into the categories, but for nonprofits, that's typically the executive director. That's somebody who manages other people. That type of person is exempt from overtime. It is a few people at your organization. If a nonprofit says to me, everybody at our nonprofit is exempt, I'm going to say no. Like, that's virtually impossible. Show me your staff and let's talk through these to see how they fit into these categories. Most of your employees are going to be non-exempt, meaning they're eligible for overtime. So you want them to keep their time, make sure they're accurate, make it really easy for them to keep time records. Because if worst case scenario, and we're always thinking worst case scenario, down the road, you get that lawsuit like the Ronald McDonald House, and maybe some employees, come together and file a lawsuit against you. You're going to have to prove that they did not work over 40 hours in a week. So you're going to need to show time records that are accurate. That's a real quick overview of overtime. Let me go back, Randy, and cover minimum wage. So minimum wage is the other piece of the FLSA. For all of those non-exempt employees, you have to make sure they're being paid minimum wage, which in Georgia is still what, $7.25 an hour. But where this gets tricky usually is if you have like students that maybe are working through in the summer, and instead of paying them by the hour, you're giving them a stipend. It's possible that you could get in trouble if that does not equate to minimum wage. If you take the stipend amount that you're giving them divided by the hours worked, or the hours they're saying they worked, because remember, it's, you're going to have to prove that what their hours were, then, and it's less than $7.25 or whatever it is, then you could get in trouble for a minimum wage violation. I'm not a big fan of stipends, by the way, but if you're doing some sort of structure like that, again, get advice on how you're doing it to make sure you're not violating the minimum wage laws. Okay, Randy. All right, we've talked about contractors. We've talked about employees, both exempt and non-exempt employees. Now I want to talk about volunteers. This is kind of the last group who is working for your organization. And, the important thing to keep in mind is don't compensate volunteers. And you might think, well, then obviously we don't pay our volunteers, but where you might get tripped up is maybe you give a holiday bonus, give them some money at the holidays, or you give them a gift card. The IRS views gift cards as equivalent to money, cash. So if you are giving your volunteers gift cards, you could get tripped up and to having them look like employees, and then all these laws apply. So don't give, I'm not worried about a $5 Starbucks gift card, by the way, but a more significant gift card, stay away from that. So be really careful about volunteers. You definitely want to thank them. You can recognize them. You can have a nice luncheon, give them like a book or a plant or something. The IRS in their materials recommend ham or a turkey, which I always think is so strange. But find other ways than things that look like money. On the flip side, you want to be very careful about not having your employees, or careful if your employees are volunteering for your organization. The only way you can do that without that looking like unpaid work, which you'll get in trouble for, is if the work they're doing is truly voluntary. There are no repercussions if they do not do this work. And it can't be the same type of services that they perform as part of their regular job. So let me give you an example. Our church has a preschool. They have preschool teachers that teach Monday through Friday mornings. Once a year, they have a spring, event, fundraiser, and they ask the teachers, I'm just assuming, they ask the teachers to come and help out if they want to. And so it's optional. There's no repercussions if they don't come. But if they do come, what they're doing is different than their job as a preschool teacher. Maybe they're helping out at the little bake sale booth they're having there, or something else other than their typical preschool teacher job. So that's the type of situation where an employees might be able to volunteer, but just be really careful about that. We had a nonprofit who could only afford to pay an employee Monday through Thursday. And so Friday she volunteered doing the exact same work. Like that's where you get in trouble with these things. All right. Go ahead, Randy. I think that might, no, almost done with employment, and then I'll take questions. So again, when you look at everybody that works for your organization, you want to make sure you can put them in a bucket. You've got the bucket for the contractors. That should be a small bucket. Check on that. You've got a bucket for your volunteers. Make sure you're not paying them in any way. You've got a big bucket for your employees. And for those, you really want to divide them up between exempt or non-exempt employees. And you want to make it really clear who is what. I think the next slide, Randy, I've got resources, and Randy's sharing this with you so you can go to but these are, I don't know. Sorry, Randy, hopefully they can click on these even in a PDF and go to our website. If they cannot, search our website for employment. We have a ton of great resources there. Okay, I'll pause there, Suresh, and see if there are any questions.
We did have one question that came in through pre-registration that ties in here. Can you explain whether a nonprofit board member in Georgia can be paid?
Generally speaking, I think it's a bad idea to pay a nonprofit board member. It just kind of goes against the role of a nonprofit board member in providing for the organization, supporting the organization, making sure the organization has the resources it needs. So this is very much unlike a for-profit corporation. Let me just say that occasionally a executive director might be on the board of directors. So if they are paid for their job as an executive director, and if they follow the conflict of interest policy, which we'll talk about when it comes to any board discussion around their salary, then an executive director who serves on a board can be paid for their job as executive director, but not as a board member. I won't go into all the reasons, but I overall would say it's a bad idea to pay your nonprofit board members.
And I will make a mention that we do have an article on our website that specifically addresses this question that goes into a little more detail that would be good to reference.
Thank you, Suresh. All right, now that we're done with employment, which I said is the biggest area we're going to cover, I want to get into tax a little bit more. So every 501c3 organizations is responsible for filing some version of the Form 990. I'm going to go over what those versions are. And so the deadline for those each year, I can't remember exactly how it works, but if you're on a calendar year, fiscal year where your fiscal year ends on December 31, it's going to be due May 15th. You can get an easy automatic extension just by requesting it. But you are required to file those annually. If you don't file those every 3 years, you will lose your 501c3 status and may have to just start over. And at that point, donations to you are not tax deductible. So you really want to keep up with these. And I'll mention you want the board to review them before you file them. I'll come back to that. But Randy, go ahead, and I want to share a story with you. This is a a bad photo of something one of our clients got several years ago from the IRS. And I don't know about y'all, but as the executive director of a nonprofit, anytime I get any piece of mail from the IRS, I get nervous. Even if I know it's just an acknowledgement of our extension on our 990 or something, I just get nervous. But I can't imagine opening a piece of mail from the IRS and having them tell me I owe over $9,000 to the IRS. But that's what happened to this organization. And that was because they failed to file their 990. I think this one failed to file like at least 2 of them. And once you fail to file, there are fines and penalties that kick in and just keep increasing every single day. So as you can see, it can add up over time to over $9,000. So I mentioned that you can eventually lose your tax exempt status, but even in the meantime, you can get big fines and penalties for being late. Next slide. So make sure you have that deadline on your calendar and really give yourself time to get the help you need to complete that 990. You may have to hire an accountant. You definitely want to give time for the board to review it. On the Form 990, it asks the question, has your board reviewed this form? And you want to be able to say, yes. I'd be embarrassed to say, no, my board hasn't reviewed this form before I filed it with IRS. So just bake in some time to get it done right, have board members review it, be able to kind of make any corrections if necessary. On that 990, I'll just note that it asks for changes to any governing documents like your articles or bylaws, any changes to your mission statement or activities. You do need to disclose those to the IRS when you submit your 990. Be sure to do that, especially if you're making a change to your mission. Next slide. I mentioned there are a few different versions of the 990, depending on the size of your organization. There's the full Form 990, which is a lot, I can tell you. The 990 EZ, if your organization has gross receipts of under 200,000 and assets of less than 500,000, you can file that short form. It's still, something you want to take time to fill out, but it's not as much as the 990. And then for organizations with gross receipts less than 50,000, you've got it easy. They call this an e-postcard because it is the size of a postcard. It's basically your name and address. You file it electronically. If you come to me and say, oh, we didn't file our 990 in for 3 years, I'm going to be super frustrated with you because there is no reason you can't go online and fill out your name and address. I will very briefly mention there's a 990T, which is totally separate from the 3 990s. Any organization that has unrelated business income, business taxable income is going to have to file this. We're not going to get into UBIT. We don't have time on this one, but that's another one. If you're getting income from activities that are unrelated to your core mission, and it's over $1,000, you're going to have to get help filling this out. Okay, next slide. Any questions before we move on from that, Sarisha?
We do have a question that kind of goes back to the previous question number 2.
Yeah.
Chuck is asking, are board members liable for volunteers who get hurt, even when the volunteer signed a liability waiver?
Chuck, we are going to cover risk management, maybe question 5. I don't know that we'll get to it today, but we may, and I will get to that question. Remind me, Sarisha, if I don't. Okay. Thank you. All right, I want to talk about conflicts of interest policy. We just talked about the 990. Another question the IRS in the 990 is, do you have a conflict of interest policy? And I think it even asked, does your board sign an annual disclosure statement? This is another question you want to answer yes. Remember, the 990 is publicly available. Anybody can go on GuideStar and see your 990. I want people to know that we have a conflict of interest policy and we follow it and have the board member sign something every year, because that's certainly a best practice and an expected practice. Next slide, maybe. So I share this story as just an egregious example of not following any sort of conflict of interest policies and procedures. This is an organization that was a pretty big nonprofit in Georgia, Angel Food Ministries. And they had on their board multiple family members and friends of this organization. They were also all paid employees of the organization, and ultimately they pled guilty and went to jail for taking millions of dollars from this organization. They used their close relationship with this organization and with the other board members to benefit themselves personally. That is ultimately what a conflict of interest policy is trying to avoid. This is an extreme example, but an example can come up. Let's say, for some reason, this has come up several times where a board member owns a printing company or their spouse owns a printing company and the nonprofit needs some things printed and they go to the printing company and get that done. That may be fine, but you're going to have to follow the conflict of interest policy. Otherwise, it could be seen as them taking advantage of that personal relationship to benefit themselves personally. So anytime you have a situation where you have a board member who could benefit financially from their relationship to the organization, you're gonna want to make sure the board kind of vets that and goes through a procedure, which I will talk about in just a moment. Randy, if you go forward. So anytime you have a situation like that come up, or maybe a board member owns an office building or some space and the nonprofit needs some space and they want to rent it from the board member, here's what you do. Basically, that board member with the personal interest needs to stay out of it. The rest of the board needs to review this proposed transaction, get the facts, do your diligence, find out what are the comparable printing company quotes or properties that you could rent, find out how much they cost. If it's a property, is that really the best location for your organization? What are the pros and cons? Walk through all that, make a decision, and then document that decision. So if anybody questions it down the line, you can show here's why we made that decision. You may very well move forward with that transaction with a board member, but you got to make sure you go through these procedures to show that it truly benefit the organization and not just this person personally. Their IRS does have an annual disclosure statement for conflicts of interest that, or they like to see that you have the board members sign every year, just affirming that they're familiar with the conflict of interest policy. They do not have any conflict of interest. On our form, we list all of the vendors that we use at Pro Bono Partnership above a certain amount. And just the board members are able to check and say, I don't have any relationship with any of these. So that's it on that one. All right, here is, yeah, go ahead, Sarisha.
We do have a question regarding conflict of interest policies. How's that relate to a relative of a board member?
Yeah, great question. That will be in your conflict of interest policy, who qualifies as having a close enough relationship. I think generally it's certainly the spouse and the children. And beyond that, I can't remember, but we have information about that, how direct of a relationship it could be. It could also be a business relationship in certain situations. So that is something you need to make sure you've kind of laid out in your policy what's acceptable or not. All right. Looks like we have time to get to question 5, which is on risk management. So it's good to be thinking as a nonprofit organization about potential risk for your organization, ways that somebody might get injured, and then think through what your organization can do to try to prevent those risks from happening and try to mitigate those risks if they do. So Randy, if you can go to the next slide. So unfortunately, there are lots of examples of people getting injured and a nonprofit is involved. This is one I saw in the news last year that was really tragic, where a woman was driving a van on 285. was driving recklessly and ended up getting into a crash. I think 7 women were killed. And the woman worked at a nonprofit. It was the nonprofit's van. They were driving to a nonprofit event. And it came out that the driver of the van, who was the employee of the nonprofit, had a warrant out for her arrest for drug charges, did not have a commercial license required to drive this van, had more than 15 people in a 15-person van. There were several kind of red flags there. So horrible, horrible, tragic situation. This is truly like a worst case scenario. And you look at what, that nonprofit could have done differently to help avoid something like this. Car crashes happen. You can't avoid, prevent every car crash from happening if, your organization involves driving. But what can you do to try to limit the possibility of something like this happening? Those are the kind of things to think about when it comes to risk management. But it's not, always as tragic as this. Somebody could just get, an injury, a broken bone or something at your organization. And you want to just be prepared for any type of injury. So Randy, you can go ahead. So the question, and you'll have to remind me of the question in a minute, Sarisha, but one question was liability releases. We strongly encourage our clients to get releases, both from participants, but also from volunteers in your organization, because volunteers could get injured as well. And what these are is basically saying, I understand that there are risks in me participating in this activity. I accept those risks. I will not hold the organization, its board members, et cetera, responsible if I'm injured. In a situation where, we got an organization that works with at-risk kids teaching basketball. I could easily imagine one of the kids, breaking a bone, or a volunteer coach spraining an ankle playing basketball, but they've signed a liability waiver that says, I understand their risk in playing basketball. I'm not going to hold the organization responsible for that. Those are generally upheld in Georgia, so they're a good idea to have, particularly because you can't even imagine all the ways people can get injured. We've had volunteers get injured when they slipped at a volunteer appreciation holiday party at a nonprofit and they threatened to sue. I mean, all sorts of things come up. So good idea to have these. Obviously, if it's a horrible situation that results in death, that's probably not going to be enforced by the court. But in most situations, you're going to get some protection by having just a simple liability release. Go ahead, Sarisha. Sorry.
Rachel, I think the question was more related to the board member and what's their liability in the event there's no waiver.
Well, whether there's a waiver or not, board members get some protection from liability because it is a nonprofit corporation. As long as you're functioning like a corporation, board members get some protection from personal liability. So that's where corporate governance comes into play. You want to make sure we've got some guidance on this as well. You truly are acting as a nonprofit corporation, having board meetings. Board meetings are independent and living up to their duties, so they have that protection from liability from something like an injury. There are other things you can do to protect the board. You can, this is not my expertise, but you can put some language in your articles to kind of ensure that they've got some additional indemnification. You can, and we'll talk about this, you can get, you want to make sure the organization has liability insurance that will cover something like this, so they won't go after individual board members. So generally speaking, the board has protection from personal injury type things. All right, next slide. Andy. Oh, this is it. Okay. Another thing you can do to avoid injury. And when I talk about injury, I'm not just talking about personal injury, physical injury. We can talk about all types of abuse, unfortunately, are risk you need to be aware of, especially when you're working with vulnerable populations, children, the elderly, people who are mentally disabled, things like that. You want to make sure you are protecting those populations in particular, but by having background checks done on anybody who comes into contact with them, particularly if they're working one-on-one, if they're not supervised, that's a particular risk area. So even if your clients are not vulnerable populations necessarily, but you have somebody working one-on-one with them, you just want to think about what are the things, what are the risks in those situations and how can we avoid them? And background checks can be helpful there. Running criminal background checks on your volunteers, on your employees, thinking about how often to run those, because you might run one on somebody when they join the organization, but they've been volunteering for 5 years. Who knows what's happened in the meantime? So background checks are an area it's a good idea to get some advice on for your particular organization, what you'll need to be doing, what kind of checks you need to be running. But every organization should think about whether they need them and how to use them. Criminal background checks, if you have drivers, definitely doing driving, motor vehicle, driving checks. Even if you have somebody working with the financials of your organization, you might want to run a check on them as well. So we are big proponents of background checks. There is a law requiring that you get their signed consent before you do that. So we've got some guidance on how to do that as well. Okay. All right, a few other things to keep in mind when it comes to risk management, especially if you're doing anything that could result in injury, kind of an expected injury. If you've got people, doing home repairs and they're up on ladders or using power tools, for example, are you giving them the training on how to do this, on how to do it safely? Are you giving them tools that work, and aren't going to result in injury? And are you training your staff to be able to do first aid? Like all sorts of things you need to think about to help avoid these injuries. Again, they're still going to happen, but what can you do to try to limit those and mitigate the injury? Another type of injury you may not think about is becoming much more common, and that is injury to, taking the personal information of somebody. Our clients are facing this a lot more often. They're collecting social security numbers, dates of birth, et cetera, from their clients because they're required for a grant, for example. If that information is stolen, that is an injury to that person. And there are laws about what you might need to do in that case. So you want to be very protective of any personal private information you are collecting from your clients, your staff, your volunteers. If you're doing a background check and you take their social security number, you've got, personal information about them. We actually had a client, an intern. They caught an intern taking pictures of all the client applications to get the personal information, and he was selling that. So this is something to be aware of. You might get a laptop stolen from your organization, or somebody loses a laptop with all this information on it. That is a serious problem, and one that you can definitely try to mitigate by being very careful with that information, by getting rid of it as soon as you no longer need it, for sure, by asking, do we really need to collect this? I would definitely get some guidance if you are responsible for collecting that type of information on what you can do to avoid that being taken. Any questions on that, Sarisha?
No, we don't have any questions on that. We do have a question going back to conflict of interest. Would you want to cover that now or at the end?
Let's finish up and then let's come back to that, okay? Because related to risk management, part of risk management is insurance. Notice I started with risk management because I want you to think more broadly about what we can do to avoid it. And then if it still happens, what insurance can we have to protect the organization? Next slide. So I am not an insurance broker, but I get the question a lot. And what I recommend for nonprofits is that they absolutely have some sort of a general liability insurance, property and casualty, so that if, with a focus on the casualty, if somebody gets injured at your organization or doing an organization activity, you want to have some type of insurance to kick in at that point. And even if you have a small nonprofit that can't afford any other insurance, try to get that insurance, because I think that seems to me like the most likely risk and a place to start. Other types of insurance you should definitely consider. And for a small nonprofit, maybe work to build up to a point where you can afford it. Employment practices liability. This covers the organization if they get sued by a former employee or something. I've definitely seen situations where organizations had this, and it really, really was helpful when they needed, to pay for that defense of the lawsuit. Is usually what you need it to cover. But even if you do have to have some sort of a judgment, it's can give you some coverage there. So consider employment practices liability. I get the question about D&O or directors and officers insurance a lot. This goes back to the question about board member liability. Directors and officers insurance doesn't kick in if you have a physical injury. That goes back to your general liability insurance. D&O only kicks in usually if there's some sort of like financial crime or something where the directors and officers were not living up to their duties. So great thing to have. Sometimes you'll have board members who insist that you've got a D&O policy before they'll come on board. But I just want to make sure everybody understands that's worthless if it comes to your typical, physical injury that you're having to defend. Workers' compensation. In Georgia, every employer is required to have workers' compensation insurance if you have 3 employees. Remember I said earlier, really keep in mind that number 4 employees, going back to the unemployment insurance. The other number to keep in mind is once you hit 3 employees, you're going to have workers' compensation insurance. For nonprofits, it's a little tricky because sometimes they even count unpaid board members as workers, and you get up to 3 before you have even 3 paid employees. We've got an article on this to give you a little more information. It's confusing, so I'm not even going to try to get into it here, but check with somebody to see if you need workers' compensation insurance, and definitely get that because it is required by law. All right, that's it on insurance, and I think we're good. So Sarisha, what was the question?
I just want to say first that we have chat enabled now, so feel free to use chat or Q&A feature if you have any additional questions for Rachel. So we have one question about conflict of interest policy, and the example is that if an executive director is also CEO of a business, and she allows the nonprofit to make copies at the office copy machine for free, does that need to be put in a conflict of interest policy?
Okay. So it's free. So the nonprofit is not paying for it. So I would say you don't even need to run that through the conflict of interest policy because you're not benefiting personally in any way for it. You're doing a service for the organization. If you were to charge for those copies, even if you were charging only your cost for it, or just, a minimal amount, I would run it through the conflict of interest policy because you are getting some sort of a financial benefit from it. But if you are offering something for free, I don't see that's necessary.
And how about this one? How long should or can a founder of a nonprofit continue to serve on the board as a board chair or board member?
I can't answer that question. It's not so much a legal question. It's a very good practical question that, has a lot of implications for the organization, but that's, yeah, I'm sorry, I don't have any advice for you on that.
And we don't have any further questions for now. We'll give our audience a couple of minutes if they want to type anything up. But in the meantime, I will make a plug to mention that we'll have part 2 of this presentation where Rachel will cover the remaining 4 questions that board members can ask to make sure that their nonprofits trying to be as legal as possible. And that will be on September 29th. But yeah, we don't have any further questions, Rachel.
Thank you, everybody. And that was a lot of information. So let us know what questions you have.
And thank you, Rachel, for all this practical, fantastic information. And also thank you to our viewers for joining us today. I'm going to include a link in the chat that we would love for you to complete because your feedback is really helpful to us to make sure we're tailoring this to you guys and giving you the best information that we can. So thanks everyone for joining in and have an awesome day.